Finance Minister Pravin Gordhan announced that the National Treasury, in accordance with the Constitutional Court's order, submitted its report today. This means President Jacob Zuma will now have to pay 7.8 million rand towards the non-security upgrades to his Nkandla homestead. And joining us on the debate, we have Tshepo Khadima. He's a political analyst, and Martin Hood is with MJ Hood and Associates. Gentlemen, thanks so much for your time. Really appreciate it. I mean, I'm surprised to see just one-liners, particularly from the opposition, with regards to this reasonable percentage that President Jacob Zuma has to pay. But what does this say, Martin, around the confidence in the judiciary, which finally brought us to where we are today?
It was never about the money. It was about the principle. It was about the principle of establishing the supremacy of our constitution versus what happens in Parliament. You can't put a price on that. So it doesn't matter if it's 7.8 million or 700 million rand. Even the president realized that he has to bow to the constitution, even though he was found to be in contravention of the constitution. That's now settled in our law, and that was a very, very important principle. And I think we also mustn't forget, people are saying that the amount is too little, and I don't think it's going to satisfy a great part of the public, but I don't think that the presidency or our Minister of Finance is going to do anything untoward that would upset the Constitutional Court, because it's now been established exactly where Parliament and the Constitutional Court and our Constitution fit in with each other. That's priceless.
Is this really just about compliance, as Martin is saying?
Look, I think it's maybe beyond that. There are a lot of questions that, in my opinion, still remain unanswered. The cost determination, which we are led to believe is 7.8 million rand. One has to ask a question. The lawyers here would use the Latin phrase, ceteris paribus, all things being equal. At that point in time, what were the building costs of a similar structure, of the similar specifications? And are those costs reflective? Because it is an established fact that the costs at Nkandla were far above what was deemed to be the norm in the construction industry at the time. And that is a question that I think remains unanswered, and is not only pertaining to Nkandla, it pertains to all major public works projects in the country, where we've seen that there's been a lot of overcharging. So when you arrive at the figure of 7.8 million rand, I think we're still not very much settled as to how that figure was arrived at. What would worry me looking in is that we see the continued leakage. Here we are, the National Treasury has presented, as required by the court order, has presented their cost determination. But that cost determination invariably has to be made the order of court. So before it is even made the order of court, already we are seeing that there's quite some level of detail which one cannot say whether it is the true account as presented by National Treasury or not. So the lawyers, once again, I think maybe they will agree to this, that the legal principle of sub judice is not very much observed in our country to this day. And that also pertains to, I think, what the conduct we have seen in recent times, particularly from the office of the public protector, that the reports of the public protector invariably find that they get leaked either in draft or in final form before they are even presented by or read in public by the public protector. And that, for me, it is very worrying that we see in this leakage. And also the question of, well, how was that figure arrived at? And of course, it will deal with the issue of affordability, which I think that the court did not maybe take into account at the time that they made the order as they did.
So this is not the complete story. I mean, it doesn't mean that with President Zuma now paying back the money, this will be the end of Nkandla. We heard another analyst saying that this Nkandla has become a poster for corruption, if you will, and it was a reputational damage to Jacob Zuma. But I want to come back to the procedures going forward now. The Constitutional Court has received the National Treasury's report. They will study that, and then what determination is likely to come out of that, Martin?
They have to accept a figure. And in our law, in the absence of a determination made before you go to court, you have to determine what is reasonable. And my understanding of the report is that 2 independent assessments were done, one by the South African Association of Quantity Surveyors, and that in turn was verified and assessed by another series of professional quantity surveyors as well. And they came up with what should be the reasonable cost of that amount of building. And it seems to have some accuracy to it, because it's about 80% of what the public protector recommended. But as my colleague has mentioned, whether that is the actual cost paid for that construction is an entirely different debate. And I think, unfortunately, it does fall outside the ambit of the court order, because the court order was to determine whether Parliament can make a determination as to whether to follow the public protector or not whether the actual cost of the upgrades was a reasonable amount. So what's going to happen is the Constitutional Court will look at the numbers, they will accept it, or they have a discretion to say, we're not happy with this, go back and do something else, or do a recalculation, you haven't done this, you haven't taken that into account. And once that figure is accepted by the Constitutional Court, it will be made an order of court, and President Zuma then has 45 days to pay it.
Is it likely, though, that the Constitutional Court may come back and say this 87% or so is unreasonable as a percentage for the president to pay back, based on whatever mitigation, arguments that they may have?
The way our courts work is judges are not experts. They rely on an expert to come to them and say, if you want to work out a number, we as a quantity surveyor can do it. That's how we do it. That's our methodology, and that's the ultimate number. So they will be guided to a great extent by what is assessed by the quantity surveyors. So unless there's a material flaw in the reasoning or a material non-compliance with the court order, the probability is that the Constitutional Court will accept it.
And would the court also consider, Tepo, in that President Zuma was under the advice of the Parliament, under his legal team, that this is not a decision that he had made on his own volition. So he was informed, in a sense, that Public Protector's report was not binding, and that security features or other exterior features on Nkandla were actually legal and legitimate. Can the court use that argument to say he had a different logic at the time and didn't deliberately defraud the state?
No, not at all. I think the issue here at hand would be that, can the court actually question? I doubt that there will be any legal basis for them to question the quantum that we now have, which is reported to be 7.8 million rand. We obviously wait until tomorrow that it is formally announced by the court. Because at the beginning, the court did not give clear guidelines. They left National Treasury to use a discretion, of course, well within the professionally accredited firms, as we find that they allege that there are 2 firms, or they report that there are 2 quantity surveying firms that independently did the work to arrive at the figure that they are. So I can't see the court then say, well, because they never gave the guideline in the beginning. However, should the president take issue in the manner in which the base cost, how it was arrived at, to then come to this figure of 88% that is now deemed to be due and payable by him, maybe we might see that the president can approach the Constitutional Court to go and say, well, actually, I'm being prejudiced. Whether there is political currency and goodwill to be able to achieve that, I doubt. So in all accounts, my reading is that probably the president will have to, once this is made an order of court, that's the amount that is due and payable, we most probably are going to see him having to find other ways and means of being able to pay within what one can regard as a very tight timeline. Because when you take into account what the president earns, and you take into, this effectively, maybe in my opinion, 3 options that the president has. It's either to approach a institution or a lender who would then advance a loan that will be paid off over a longer period so that he can meet this obligation, or he might have to do fundraising which we know that the Secretary General of the ANC said, well, he doesn't believe that would be legally acceptable. I doubt that assertion that he made, but I think that probably that's what the president might have to do, because I can't see how you probably maybe would have anticipated that there's this amount that is going to have to pay then in 2011.
Yeah, sorry, Tsepo. Should there be shared accountability? And reason why is, again, that he was advised clearly, wrongfully, around what he's entitled to do. And especially when it came to the contractors, the public works, and the different ministerial departments or teams that have approved this budget in the first place.
I don't think so, because first of all, the order of the Constitutional Court, I think, is what we would call a final order. They've ruled. And all they've said is, go away and you, Government Ministry of Finance, go work it out and come back to us. We're merely going to confirm it. The issue of all the other contractors and the amounts and the background to the building of Nkandla was actually not put before the Constitutional Court. They haven't considered it, so I don't think that they are going to do anything about it, because it's not before them and it's not part of the confirmation process of the amount that the president is going to have to pay back. So the question of shared responsibility, I don't think, is an issue that the Constitutional Court has or will rule upon unless there's an entirely separate matter put before it.
But shouldn't the president pursue that, though, in the sense that there's other people that have benefited unduly? There's the inflation of prices that he himself may have overlooked. There was oversight or lack thereof.
Politically, that would be very dangerous, because it would just keep this debate open. And we've seen that a number of the functionaries involved, for example, the architect as well as certain civil service employees, have challenged suspensions, have challenged court actions taken against them. So if the president chose to try and make somebody else responsible, to issue a summons to recover some of those costs that he has to pay out of his own pocket, it's going to expose the entire debacle over again, but from a different point of view. And that may have very, very negative repercussions for him.
Yeah.
Look, I think one has to take into account that the Department of Public Works is already engaged in a process of dealing specifically with that issue of cost overruns and overcharging, and the Special Investigative Unit already is at work, and there's some recommendations of either a litigation and even in some instances some criminal prosecution in that regard, which was part and parcel of also what the remedial action that was recommended by, or rather issued by the public protector. Where the president is right now, I can't see him really, as he himself has gone on record to say that he apologizes that this matter has dragged on for too long. So I think he too is desirous of having this matter come to a close. The question, of course, is that, well, is this the figure that is what he was prepared for, and what action steps he has taken in anticipation of the next 45 days, or is that is something that is to be seen. But once this cost is made an order of court, there is 45 court days from that date. So somewhere in between that, I would say that he's got at least 2 months by which to go and come up with the money. The other issue I've seen is that the Democratic Alliance is said to be say, well, the figure is a little bit too little, and I can't see how they can legally sustain that argument or questioning of that figure, because they would, by the very essence, be wanting to alter the court order as already issued by the Constitutional Court, and I can't see how they would legally sustain that.
They're not experts. They can't determine it.
But Martin, I think just from a social psyche point of view, in terms of the reputation of the president or the House of Parliament, is this an opportunity for redemption for President Zuma, you think? You think this is going to go away once he's signed the check?
No. I think that he's going to go down as the first president of a democratic country in Southern Africa that was found to be in breach of the Constitution. The Constitutional Court decision is part of our law. It's a decided decision. It's got a very convoluted history that makes it very, very interesting. And above all, it was a very important principle for a young democracy to test in its highest court. And that, I think, is reflected in the very fact that although President Zuma, right at the end of the process, said, no, I'm happy now that I am bound by the public Protector's report, the Constitutional Court insisted in issuing a judgment to have that precedent as part of our law. So there's no possibility, in my view, of him redeeming himself in any way in terms of any conduct subsequent to the judgment of the Constitutional Court.
Do you agree with this, the version of Zuma's legacy, as Martin put it?
Look, we are still a young democracy. Maybe let me give a historical account of the oldest constitutional democracy in the world, being the United States. That there are a number of accounts whereby there are various presidents. In fact, right now, where the United States is resultant from the George W. Bush presidency, that they are in a state of war which was not sanctioned by Congress, which in terms of the Constitution of the United States, that is the privilege and the domain of Congress to be able to declare war. In fact, Abraham Lincoln himself, he declared war and appropriated monies, again going against the Constitution. Andrew Jackson, in fact, even said something, a more cardinal sin against the Constitution, where he said, forget the Supreme Court, get damn Indians out. When the Indians were the Supreme Court in the United States made an order that they should stay. And so what am I saying? I'm saying that when we look in South Africa as a younger democracy, I don't believe that this is the end, particularly when you are in the state of still developing jurisprudence and really establishing a country as a constitutional democracy. So was it a cardinal sin? I don't believe that it was a cardinal sin. And the reputational damage that I think some analysts are talking about, I think that is very difficult to quantify. In my view, I think history, which is the fairest judge of all, in the end will come to a point where it will balance all this, what we regard to be the sins against the Constitution by the President.
Exactly, but with all things being fair, though, there is a process, and as you mentioned, President Zuma had apologized once he realized and took account of the sequence of events that brought us to the Constitutional Court in the first place, so that surely there must be finality, there must be a closure, that once the payment has been made, we assume that the court will agree with the percentage as proposed by the National Treasury, that this will be the end of it, Martin. Why should it still linger and hover around?
It's going to be an historical fact. It's going to be a legal fact. And it's a turning point. And that can never be underestimated legally in our jurisprudence. It's a turning point because effectively what we had was a challenge by Parliament to the Constitutional Court. And Parliament lost. And that established the correct separation of powers and the correct juxtaposition of those parties against each other. That is an absolute seminal point in our law, and it is going to be part of our law into the foreseeable future.
But I just want us to have the peace to say, you know, this will never be another talking point. It won't make headlines. We've come a long way. It's been over 6 years, if not longer, and the monies that have been spent in legal fees, etc., going back and forth between all these parties. Now we have a figure at least that we can accept or not, to debate, but once the president has done so, can we move on?
No, it'll be over. It'll be over.
Why not?
Maybe I'm a little bit more cynical than the rest, but I think that this matter is going to continue to be spoken about because it really has got very little to do with whether or not the president pays the money. It has everything to do with him being in office. And it is my own assertion that there is a whole host of other reasons on why people will find, or there are other parties that would want to find something to say about the president. And for now, as we stand, they will keep on hammering at this issue. Whether or not it will generate any currency, particularly where it matters most in terms of elections, I doubt that it would. If anything, I think it has got the effect of reducing the value of the political currency that any political party hopes to generate. Yet, we see that even to this day, the Democratic Alliance already showing a level of unhappiness. In their view, they were thinking that you should have been paying the whole quantum of that was spent there including even on the facilities that were built on the outside. So I think it's going to continue to occupy the media, but more so because of the man in the position more than the principal.
So we're not playing the ball here, as it were, Martin. We're actually playing the man.
Well, I think that's the case, but I have to disagree. I don't think that any attention to Nkandla is going to get any traction once he's paid the money, because there was a report, he challenged it, he lost, he paid. He's quite entitled to turn around, and the ANC is quite entitled to turn around. We've done what was required of us. What more is there to debate? So I think that it's going to be a relatively dead issue after he's paid the money. There's going to be other things that stir the interest of the political opposition and the media, for that matter. I'm not saying specifically in relation to the president, but I think it's going to be an issue that dies fairly quickly.
Yeah, and then the Concord, of course, would have to be sensitive as to should they reject this figure as being too high and then, get the president to pay a more reasonable percentage than this one. That could create another
I don't think that they would. But for me, I think what also is of, I'm more interested in seeing what happens. What have we learned? We have what we have. It is an established legal case, part of the jurisprudence. But where do we go from here? I think more so in terms of the work of the public protector. If I'm looking back, I think the future matters of this nature, it would help if there was better guidance in terms of how you arrive at the cost. Because for me, what has always been a problematic statement was, in the report, was the president must pay some money without giving any guideline as to how you arrive at that some money, and it was never clearly defined. And I think the Constitutional Court also, by steering away from that and say, well, you make a determination that is reasonable, discretion, I think that was an issue that maybe future public protectors need to be a lot more decisive on these matters.
All right, we're seriously out of time, and thanks indeed, gentlemen. We had invited the DA, the UDM and the ANC for their comments, and none were available. But in studio joining me is Tsepo Khadima, political analyst, and Martin Hood from MJ Hood and Associates. Much appreciated, gentlemen. We'll take a quick ad break. We're back with Business just after this.